Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
Welcome to Criminology Matters, the criminology podcast series in conjunction with LawPod. And today we are delighted to have Alessandro Corda from the School of Law. So you're here today to talk about your research on a particular aspect of what happens to people with a conviction, the collateral consequences of convictions. Can you tell us a bit about how you got to this area and what it entails broadly?
So first of all, thanks for having me. I first got interested in this topic back in 2013. I just finished my master's degree at NYU, and I was working with Professor Jim Jacobs at his Center for Research on Crime and Justice. He was working on his book, The Eternal Criminal Record, which came out in 2015 for Harvard University Press. So I helped him polishing the final version of the book. I was also his teaching assistant in a seminar on criminal records policy and jurisprudence, and I got really interested in the topic, and it was surprising to me how under-researched the topic was. So here we are looking at collateral consequences of having a criminal record, and broadly defined, we can talk about formal and informal collateral consequences of having a criminal record.
So what is the difference then between formal and informal consequences?
Sure. So when we talk about formal collateral consequences, we are looking at all these legal civil disabilities, legal ramification stemming from having a criminal record. So we are looking at the loss of welfare benefits, disenfranchisement, loss of other rights. We are talking about the loss of public housing and various forms of disqualification from holding certain positions. When we think of informal collateral consequences of having a criminal record, we're mostly looking at stigmatization and the enhanced stigmatization of having a criminal record, especially in today's digital age, but also to all these background checks that are ongoing in our society today, not only for employment purposes, but also when it comes to random searches, when it comes to a date, a neighbor, an acquaintance. So we are living in a society where criminal background checks, of course, with different nuances in different jurisdictions, have become really widespread and basically they blew out of proportion.
Okay. And so you have these material, I guess, outcomes, and which seems to be more of this punishment of poverty, taking away welfare, exclusions from public housing, and then this symbolic denunciation that keeps on giving. In your paper, you talk a bit about the challenges these pose for reform. What are the challenges? What are the breadths of the challenges?
So from a comparative perspective, we must say that, for example, in the US, all these legal collateral consequences are not formally a part of the sentence imposed at the sentencing stage of the criminal process. So one adjudicated defendant is sentenced to a term of imprisonment, probation, fine, suspended sentence. But then regardless of the punishment imposed at sentencing, you know that outside of the criminal justice system, outside of the realm of the criminal justice, many legal collateral consequences will soon follow. So the problem here is about the impact of the ramifications of having a criminal conviction, having a criminal record. So from a law and policy perspective, as I write in my paper, this is really a question of proportionality. The problem here at center stage is proportionality. In the US, the Supreme Court really adopts a formalistic and differential approach when it comes to define what constitutes punishment. So when it comes to the Eighth Amendment, cruel and unusual punishment, the Supreme Court is not willing up to this point to consider as punishment all measures that are not formally labeled as such. So again, adopting a very differential approach when it comes to the labeling game played by federal and state legislature. So sex offender registries are not deemed as punishment. Other measures like civil disabilities, disqualifications, loss of voting rights, and so on and so forth, are not formally viewed as punishment. So there's nothing really putting a limit and limiting the ability of the sentencing judge to impose a sentence, and then on top of that, the defendant, the adjudicated defendant, will also have to suffer from all these consequences. On the other hand, in Europe, historically, what in the US are known as collateral consequences are known as ancillary or additional penalties, and they are listed formally in penal codes as part of the arsenal of criminal sanctions. In the UK as well, we have this idea of ancillary orders that are formally imposed at the sentencing stage on top of other more traditional forms of punishment, but at least they are taken into account. In England and Wales, they are formally considered in the sentencing guidelines process when it comes to the imposition of the sentence. So at some point, if ancillary orders apply, they must be taken into account by the sentencing judge when it comes to considering the overall proportionality of the tariff, of the punitive tariff being imposed on a defendant. In the US, this is really out of sight, so sentencing judges, they're not even aware of all these additional ramifications, civil penalties, collateral consequences that will hinder the life of an adjudicated defendant after the criminal process basically ends.
Mm-hmm. Okay. And you talk about proportionality. So what you're saying is that it doesn't even have to be an imprisonable offence for people to be impacted?
Absolutely. So we tend to focus on, and rightly so, imprisonment, the pains of imprisonment. But then when it comes to criminal records, it's not really about the punishment imposed at sentencing, be it imprisonment, probation, fine, a suspended sentence. So even if a person doesn't go to jail at all, then he will still have to face these ramifications of having a criminal record in the employment context, in everyday life context. So it's not really about, when we talk about criminal history records, the punishment, the nature, the type of punishment imposed at sentencing, but rather having a criminal record on one's file when it comes to background checks, and when it comes even to newspapers and having the news out there, having this information out there. Yeah. It's not really about the punishment, it's really about being a convicted offender as such.
Okay. And so you and Sarah Lagesson have drilled down into some of the implications of these issues further. Could you tell us about some of the changes that you have noted as having occurred around this issue of criminal records disclosure?
Absolutely. So first of all, let me say that Sarah Lagesson recorded one of the episodes for this series. I think it's episode 5, so let's go check it out. So we have this article forthcoming in the British Journal of Criminology, where we basically have a look at how things work on the ground when it comes to criminal records disclosure. We have case studies from the UK, from Sweden, from the US, and then we also take a look at how Google manages criminal history information following the famous right to be forgotten judgment of 2014. Basically, here we highlight how over time And thanks to technological developments, a new private sector basically developed, and basically these private companies are profiting increasingly from criminal history information available out there. And up to this point, research has mostly focused on the US, where, in light of this First Amendment absolutism, criminal history information is normally considered as public available information. There's no restraint as long as it's something created as a result of adjudication in the criminal process. Here we are squarely looking at public information, and nothing can really prevent the general public from accessing this type of information.
Can I just ask, because I find that astounding, the general public can access these criminal records information. Is that what you're saying?
Absolutely, absolutely. But what really changed with all this new digital age is that until, I would say, the 90s, as the U.S. Supreme Court said, criminal history records used to exist in practical obscurity. So, of course, they were public information. They were publicly available. But if you had a conviction in Vermont and you lived in California, it was really hard for an employer in California to really check whether or not you had a conviction in Vermont or Massachusetts or in another state. Now, with technological developments, we have this digital databases, and then we have private companies harvesting these government databases. And large companies have assembled over time these huge databases collecting information from each and every state. So now, basically, it's very easy to access everyone's criminal history in each and every jurisdiction in the country by just paying a very small fee. Then you have open record states where you don't even have to go to a private commercial vendor. Florida, for example, is known as the Sunshine State, not only because of the weather, but also because they have this very open approach to the dissemination of government information, including criminal history information. So they have this beautiful website where you can just go, pay by credit card, and you can have all the criminal history information you want. So we have this huge problem with these commercial vendors in the US. And in this article, we highlight the way these commercial vendors basically scrape and obtain this information. So we have this case in Colorado where the company that was hired to help the government develop a database actually at the same time was duplicating this information to create its own database to be exploited afterwards for commercial purposes. But then we also take a comparative look, because we have this assumption that when it comes to criminal record scholarship, that the US, it's really this evil land, and then Europe, it's really kind of this idyllic continent where criminal records information and criminal records are managed properly. But in this article, we highlight that this is not really the case, at least looking at the UK, and then we have this case study on Sweden. Mm-hmm. The UK is really kind of a middle ground when it comes to penal policy in so many regards, but this is also true when it comes to criminal records. We have this demand for criminal history information. We have a rather complicated and layered system of criminal records disclosure in the UK. Basically, we have three types of checks: basic checks, standard checks, and enhanced checks. We know that under the law in the UK, of course, we have different regulations, but they basically replicate the same rules in Northern Ireland, Scotland, and England and Wales. We have convictions up to 4 years for adults that become spent after the passage of a certain buffering period.
Can I ask you, we have some NGOs in the UK who campaign to ban the box with regards to people having to tick and disclose about having criminal convictions. What do you think about that project to ban the box?
At first, I really think high of this effort. So the idea is really, if we cannot prevent employers, for example, at all from accessing criminal history information, then we can try to regulate the moment in time when they can access criminal history information. So the idea of behind the ban the box campaigns in the UK, in the US, is really to say, if you have a job applicant, you are not allowed to screen out that applicant simply based on criminal history information. You can only ask and check about prior convictions, criminal records on file with this person only later on in the hiring process. For example, when an offer has been made, after you have had an in-person interview with this job applicant. So the idea was that of not, and is that of not discriminating against people with a criminal record. So, okay, this person on paper, if I look at his or her CV, has wonderful qualifications, but then I'm not really willing to take the risk because I can see, without having had any in-person interaction with this subject, that there's a criminal record there. I really liked the idea at first, but then recently, these are US studies, there's this understanding that in this risk-averse times, employers, they tend to more or less explicitly, more or less consciously to look for proxies for criminality. Okay. So eventually we have people of color, for example, who are discriminated, ended up being discriminated. I think that the Ban the Box is an absolutely great initiative, but we should really try to reshape our cultural approach to criminal histories and people with criminal past. What's the point of ruling out a person having an old criminal conviction? We know that after 7 years, 8 years, one person has basically the same likelihood of committing a crime again of a person who has never been convicted. Okay. But why, culturally speaking, we are still more willing to consider and give a huge weight to this factor from a distant past vis-a-vis other credentials? So we have a person with a fantastic employment history, with fantastic degrees, with great qualifications, with great letters of reference. This person may have letters really certifying his moral character, but then still we are willing to give more weight to an information that has completely lost its predictive value, in a sense. So I think that here we must have a cultural conversation about how we assess and how we give weight to criminal history information.
That's really interesting. And I think it's really interesting too, this commodification that has occurred of criminal records, this idea that everything is for sale and everything is for profit, you know?
Absolutely. So in this article with Sarah Lagesson, we developed this new paradigm of penal entrepreneurialism, as we call it. So we noticed that when it comes to the involvement of private actors in the criminal records industry, we are observing a shift from what are traditionally the characteristics of the first generation penal entrepreneurs. So Malcolm Feely of Berkeley famously wrote this piece on punishment and society, published I think in the early 2000s, where he really described how penal entrepreneurs work and the role they have played in the development of penal policies and practices. Then Richard Jones from Edinburgh wrote another very influential piece on the digital rule as applied to punishment and control techniques. And basically we combine their two accounts to develop what we term the version 1.0 of penal entrepreneurialism, and then we look at the differences that we really see in the context of criminal records disclosure and dissemination for commercial purposes. And we ended up really describing this new paradigm, what we define as the paradigm 2.0 of penal entrepreneurialism.
And did you say, so people can access these records for the purposes of dating or for the purposes of whatever they want, really?
So this is true for sure in the US. This is not the case yet in the UK. But for example, this is what happened in Sweden, as we describe in our paper. So we still have some barriers when it comes to the disclosure of criminal history information. But if we look back in 2009, there was this policy announced in the UK for which courts should set up websites and publishing a list of convicted individuals on their websites in order to alert communities, and this information would stay up for a month. So that eventually didn't
no
go
prospect
through.
of vigilantism there or anything.
Exactly. But again, I think that it's really interesting to look at like all these policy mobilities and how we often tend to replicate and embrace bad policies instead of good policies from other jurisdictions. So this didn't go through in the UK, but again, you never know because we have this information and you never know what might happen. It's interesting what happened in Sweden, where they have this public access information laws, access to government information dating back to 1766, and that was always in place. But then technology came along, and so private companies, this website lexbase.sc, realized that they could access and collect all this information from criminal courts, which have been meanwhile digitized and assembled in these databases. And then basically they just released and published a website where you could just see, for example, if you had criminals convicted offenders, people with conviction living in your neighborhood, you can run a background check. And so that completely commodified this criminal history information. So it was not only about criminal background checks for employment purposes with the check being run by a public agency. Yeah. And that's the case in the UK, for example, today. So this freedom of information law combined with technology, so we say that it was really an unplanned development. And that's the same thing that, by the way, happened in the US. It was really an unplanned development arising from the combination of freedom of information laws, First Amendment absolutism, and digital technology. Yeah. So basically, this really opened the door to all these private players. Mm-hmm. So now we really have to deal with this challenge, but there's no regulation in place yet, at least at the European level. In the US, there's this huge debate about privacy, criminal records management, but then again, you still have this golem, this totem represented by First Amendment, and it's not clear whether or not we can find kind of workaround regulations or balancing principles to really introduce a new body of rules in order to limit at least the abuse when it comes to the role of private actors in disseminating criminal history information.
Okay. So in a sense, this was unplanned. Do you think that criminal justice systems have the capacity to respond to what's happening with this data?
I do think that there's this capacity. Of course, now, again, we are in the digital age, so we are not only dealing with criminal history information coming from official records. So in the paper, we also discussed the role of Google when it comes to the management of criminal history information. So, for example, following this very important ruling of the European Court of Justice of 2014, holding that that information that are inaccurate, inadequate, irrelevant, or excessive can basically be eliminated from search on search engines.
Yeah.
So we're not talking about deleting any contents, but if you just type your name on the Google on the Google website, then a certain result is delisted, so will not come out in the results following your search on a certain engine, search engine.
Okay.
So basically, what we noticed when it comes to criminal history information is that Google, which complied with the rulings, but then when it comes to criminal history information, we noticed then they added additional layers, additional criteria in order to delist information about someone's criminal past. So they unilaterally and arbitrarily in their report, in their guidelines, so their public guidelines, and then they also provide examples on how they deal with expunge spent criminal history information. Even when a conviction in the UK, for example, is deemed spent, so a person is rehabilitated on many forms. He or she can basically answer as if he or she was never convicted.
Yeah.
But then when it comes to criminal history information reported by newspapers, which are still out there because, for example, a journal, a newspaper has been digitized, so the information is out there. And if you type your name, that result can still come up. In Europe, in the UK, in other European countries, some people, they ask Google to remove, to delist that information.
Yeah.
I've been deemed rehabilitated by my own legal system, so I don't see why a private company should second-guess official policies in a sovereign state. But basically, unfortunately, this is what Google does. So they, as I said, they added additional layers, additional criterion. So they say, okay, we are willing to delist as long as the conviction, even though this conviction is expunged or spent under national law, occurred a long time ago, if the person does no longer pose any threat to the public, if it's not in the public interest anymore, they introduce consideration for public safety. So again, we have a giant private player second-guessing national law, national policy. So it's not even enough to be rehabilitated under national law if your conviction, if criminal history information about yourself can still resurface on the web, and these giant players do not simply comply with policies that have been already agreed upon at the national level.
And of course, these giant players go beyond the nation state. You know, they're transnational. And I guess that must have implications for the data too. I wonder, your piece is comparative and you write a bit about the EU directive on exchange of criminal records among EU member states. Do you want to tell us a bit more about that and maybe what you think might be the implications with regards to data post-Brexit?
So thank you very much for this question.
If post-Brexit comes, sorry.
Yeah, absolutely. I think that when it comes to the UK specifically, we have to see what kind of Brexit comes, if any. I think that with regard to access, and I will say something more in a minute, about the exchange at the EU level of criminal history information, a Brexit with a deal or a Brexit without a deal really makes a difference. So in our paper, we talk about these companies based in the UK, which basically exploit this European framework as a backdoor to get information that you could not get in the UK. So here we're talking about basic checks which would not reveal spent convictions, and usually until 2015 employers would basically get that information by resorting to what is known as enforced subject access. So basically asking a job applicant, okay, I cannot know if you have any spent convictions because this job doesn't qualify for an enhanced or a standard check, where, by the way, even unspent convictions and cautions would come up. But I want to know. So why don't you go to the police and bring me your police criminal history report listing spent, unspent, convictions, cautions, and anything else. In 2015, the government criminalized enforced subject access, precisely because that was really a practice in contrast with the Rehabilitation of Offenders Act. But then these private companies, what they do, they have these applicants signing a form, and then they at least couple and even more, I would say, because they're really popping up. It's really hard to track them all. They go to Poland, where enforced subject access is not criminalized, and they can obtain through the Polish system, which is online and has access to all these ECRIS frameworks. So they can access information about UK criminal records, and they release these companies. They release a Polish certificate with, of course, with a translation. But long story short, through this backdoor, and it's really a legal loophole, which is exploited here. So employers in the UK can obtain legally information that they could not otherwise have access to under UK law. So I think that here we have this kind of dark side of globalization and sharing information. I think that this is another interesting finding from our paper, that even if you have like infrastructure that at first sight would prevent private players from exploiting criminal history information for purposes that go beyond what's allowed on paper by the law. Then when you have, again, this transnational dimension, this sharing of information, you can have this exploitation of loopholes to create a backdoor, again, to disseminate information that, again, otherwise could not be obtained legally at home.
It sounds as if this is a hugely expansive issue that impacts a lot of people. What would your sort of take-home messages be with regards to ways forward to deal with it?
So, again, we started talking about formal legal collateral consequences, and then we ended up talking about informal collateral consequences arising from this massive crave and dissemination of criminal history information. I think that here we have like a two-pronged answer. So when it comes to formal legal collateral consequences, not formally labeled as criminal punishment, I think that, again, the idea of proportionality. We should do anything that's possible to incorporate these formally non-criminal disabilities at the sentencing stage. Because even in jurisdiction like the UK or continental European jurisdictions, where we are familiar with this notion of ancillary penalties, which are part of the sentencing stage, then we still have sex offender registries, we still have other formally administrative or civil measures that are not part of the punishment imposed. Then we have rather active jurisprudence of the European Court of Human Rights, piercing the veil and going beyond what are formal labels attached at the national level. But then this jurisprudence goes back and forth. So, long story short, when it comes to formal collateral consequences, whether or not they're labeled formally as criminal, we should design a system where criminal judges, sentencing judges, are aware when they decide what sentence to impose. They are aware, they're fully aware of all the consequences, criminal or not criminal, that will descend upon a certain adjudicated defendant as a result of this person being convicted. Okay. So we are talking about incorporating as much as possible, if not formally, we should really make sentencing judges aware as much as possible of all these consequences, so they can basically impose what is overall a proportionate sentence. So if you know that a specific conviction for a specific crime will trigger X, Y, Z collateral consequences outside of what is formally known as the penal realm, then you might reduce what is the formal, official criminal punishment. So, and it would be even better if we basically cut all the non-formally criminal collateral consequences and only incorporate a few as formally criminal punishments. That, of course, would make things much easier. But again, my idea is really to incorporate as much as possible collateral consequences into the sentencing stage. Yeah. So in the US, the recent Model Penal Code on Sentencing puts forward precisely this idea of basically compiling and keeping up to date a list of all the collateral consequences triggered by a conviction, so that sentencing judges can really have the whole picture before them as they sentence an offender. When it comes to informal collateral consequences and specifically criminal records management, we really have to basically introduce clear rules about what can be disseminated and after how much time we basically need to stop. This might be problematic because, as someone has recently pointed out, in the digital age, there's no real expungement. So probably we should take an even more radical approach when it comes to the management of criminal history information. Ideally, criminal history information should only be known to criminal justice agencies and actors. They are relevant for imposing recidivist premiums. They are relevant at the policing level. But again, to what extent we want the general public, which is not formally trained to assess, evaluate, and make decision based on someone else's past criminal history. To what extent should the general public have access to this information? We have this brand new area which my colleague Ben Levine at University of Colorado Law School termed the criminal employment law of all this involvement of private players which are not formally trained to make any determinations based on someone else's criminal record, actually making decisions based on someone else's criminal record. We want to stop all of that. Mm-hmm. So we should really experiment, first of all, by cutting down the access of private players to criminal history information. It's really unfortunate that we have commercial players profiting off someone else's criminal histories. The idea would really to give back control to the criminal justice system when it comes to criminal history information. And then there are various ways to deal with this problem and try to reduce the extent to which criminal history information are disseminated. In Australia, for example, there's the idea of a sentence without a conviction. So you are sentenced, you are adjudicated, but then judges have the discretion, following certain guidelines, to basically not record a conviction. So that information cannot be released in the first place because you don't have any recorded conviction on file.
Interesting.
Then, again, we have the idea that once the sentence has been served, the conviction is vacated. This is something that was popular in the U.S. When rehabilitation was still the overarching goal of sentencing and, more generally speaking, of the criminal justice system as a whole.
So there are a lot of routes that we could take, and I think it's really interesting that primarily within that we have the judicial decision-making stage, because for me it's a stage that doesn't receive enough focus, and it's a stage that has huge outcomes, as you've just evidenced in your research. That's all we have time for today. So can I just say thank you very much
for coming in, Alessandro?
That was really interesting.
Thanks for having me.